Court.
Good morning. Thank you very much. Please be seated. And when the live stream is ready, call the case.
Good morning, Your Honors. The matter before the court is the case entitled State of Vermont versus Aita Gurung, case number 23 AP 418. Representing the appellant, Aita Gurung, is Rebecca Turner. Seated at council table with Attorney Turner is Alex Dong. Representing the appellee, State of Vermont, is Sophie Stratton. Seated at council table with Attorney Stratton is Zachary Chen. This is a 60-minute argument with each side having 30 minutes.
Okay, thanks very much. And good morning, counsel. We'll hear from counsel for the appellant first, of course. Please come on up. And if you would, for the record, introduce yourself and your client.
Thank you, Your Honor.
Okay.
Good morning. Rebecca Turner for appellant Mr. Gurung. The right to challenge prospective jurors runs deep in our common law tradition. As our United States Supreme Court has confirmed in the late 1800s, it is necessarily a part to ensure a fairness of a jury trial. This court determined and confirmed that the selection, exercising the statutory right to select and make challenges during jury selection is a core and vital part of jury selection. And without it, a defendant doesn't have actual full right to that right. And so here that right was violated when Mr. Gurung was not present at this critical last stage of jury selection. It was the fourth day of jury draw, and the court summarily announced that he wanted to have the judge wanted to have the attorneys leave the courtroom, go into a closed door to have this final stage of jury selection.
For the peremptory challenges?
I'm sorry, Your Honor.
For the peremptory challenges component of the.
Yes, Your Honor, and for cause challenges. And so the result of that,
Ms. Turner, is it necessary to, can you show prejudice by that exclusion during two short portions of the voir dire?
no, Your Honor, it is not possible, as the United States Supreme Court has recognized in Weaver v. United States. It is actually Weaver v. Massachusetts in 2017. Because the prejudice cannot be known, it is impossible to determine. It's deemed structural error. And so
Isn't there US v. Gupta that the US Supreme Court has said that if it's something trivial in exclusion during voir dire jury selection, I think in that case, jury selection was several weeks, and then the court closed the courtroom for just a very short portion of the voir dire. And the US Supreme Court under Gupta found that it was a trivial issue, so that it did not rise to structural error.
And in stark contrast to the facts here, Your Honor, again, this was not a small part of voir dire. This was the final stage. And so
The Batson challenges, right?
that's right. And Mr. Gurung was, without explanation, excluded, as were the public. And so separate from the violation of his right to be present at all critical stages, codified in Rule 43, the right, his Sixth Amendment right to have a public trial, including the public trial of his jury selection.
I have a question. I, as a trial judge, and I think anybody who is a trial judge, has always done peremptory challenges up at the bench. Is that a violation? I mean, the defendant is sitting at the table, can't hear what's going on, but is present. Is that different than what we're talking about here?
It is different. This court considered that question in Ray Cardinal in the context of a PCR proceeding. And so there was, in the context, again, of having proved prejudice, which is different and not necessary here. It's different because Mr. Gurung was not in the same room, could not see, could not hear, could not know what was going on.
When the judges do it the way they do now. They're sitting at their table, and the attorneys approach and make their challenges.
I think that the way this court considered that question in Ray Cardinal, there was significant that there was a finding below that the defendant could in fact hear some, was aware of what was happening, and could have raised an objection. Again, the significance is that that wasn't the case here, and this procedural posture is significantly different. This isn't before this court as an IAC appeal, in a collateral proceeding. This is on direct appeal, where the right is fundamental, and we have an absolute exclusion, and there can be no implied waiver. There certainly wasn't any express waiver. But if I may, the right to presence was violated, and that is enough to warrant reversal.
So your argument is that it is a structural error. It's an unpreserved structural error. So what happens there?
It is also plain. It affects substantial constitutional rights. Obvious error, contrary to State v. Grace, which considered the nature of the error, but in a pretrial suppression hearing context, even when defense counsel gave acquiescence to his client not being present, this court still found.
So
But
then let's go back to my question then before about prejudice. If you're arguing that it's a plain error review or analysis, then how do you find the prejudice?
This court found plain error and that no prejudice could be found because it was impossible to ascertain how the defendant there could have assisted his counsel, how he could have otherwise weighed in. Because we cannot know, this court presumed prejudice there. Now, normally that is done in reserved in structural error instances. Here in State v. Grace, in the right to be present, Rule 43 context, this court applied a similar prejudice is presumed analysis in a plain error context. Under either type of error, whether this court determines this to be structural, impacting the framework of trial, or plain error, reversal is warranted. But separate from this presence requirement was also the violation of a public trial. Raised in the brief, this has been treated with absolute protection by the appellate courts, including the U.S. Supreme Court. When violated, it is structural error and warrants reversal.
Ms. Turner, you have a lovely voice, but I'm having a hard time hearing. Thank you. If you just pull the microphone.
Sure, no, thank you. I was afraid of that. I do have a soft
Thank you.
voice. I hope this is better.
I have a question, I guess. A lot, I would say the majority of what you're arguing here were choices that the attorney representing the defendant and the defendant made about, absenting himself from the motion for judgment of acquittal hearing. And so where do we draw the line between an attorney's theory of the case and plans for a case, and then later call them plain error?
This court has drawn that line when the right at issue is constitutional, and these issues here raise the same exact right. And no matter what, whether it's possible to accept a waiver that's not direct and express, no matter how the waiver is considered, it has to relay that a defendant understands the rights at stake, understands the consequences of not going forward, not being present. And then there is also some indication that he assented to that.
How do we know that?
We have nothing in the record to show that it did.
A conversation between the client and the attorney.
Also, a conversation to be had with the judge and the defendant, or a conversation that the judge could have directly with defense counsel. That's what is missing at this record. What we see here time and time again, whether it was at the time of this jury selection point, and the other issue of lack of physical presence with two other critical stages of trial where he had an absolute right to be there, the determination of his motion for judgment of acquittal that would have had absolute lasting results. And that is what this court, again in State v. Grace, interpreting what does a critical stage mean. Under this court's formulation of critical stage, a JOA motion hearing falls well within that, as does the charging conference, which he was also missing at.
I'm sorry, and you just mentioned, excuse me, Ms. Turner, the Rule 29, the judgment of acquittal. So help me understand this. I view a Rule 29 judgment of acquittal as a question of law. And I think, and tell me if I'm wrong, that if it is a question of law, then is that embraced by Rule 43?
I do not think it is a question of law. Judgments of acquittal require the court excluding modifying evidence, reviewing the evidence, and then assessing the weight of the evidence to determine if the state can meet its burden of proof. Here, though, let's look at how the court has identified critical stage, right? It's not simplistic as to whether evidence was presented or not evidence, right? This court has determined that where its results might settle Mr. Gurung's fate. Now, I don't know what hearing could be more at stake at settling his fate than a ruling on a JOA. And
Say that a defendant does not have to be present at a hearing where a question of law is being considered. And that's what a motion for judgment of acquittal is. It's a legal weighing of the evidence by the judge to make that determination.
certainly that is an exception under Rule 43. This court considered that question again in the context of a suppression hearing, which was readily recognized as involving a mixed question of fact and law. And this court determined that that exception did not apply here because it wasn't a hearing.
That's a motion
solely.
to suppress. I mean, that's presentation of evidence. Here, the defendant was already present for the presentation of the evidence. It's just the legal analysis that happens at the motion for judgment of acquittal.
I'll refer the court to my briefing where I did identify a case in the Second Circuit determining that JOA motion hearing was in fact a critical stage requiring presence. And I'll follow this up with a letter to make sure that's not missed. In any event, the jury charge conference as well meets the definition. No evidence was established, but as again, this court has determined in State v. Tribble, we know that this person with the sole authority to determine whether diminished capacity or lesser included offenses should be included in the jury charge belongs to the defendant. That was State v. Tribble.
But my understand, so when I reviewed the trial record, I understood that the trial court, after the charging conference, went back out on the bench and addressed Mr. Gurung and explained to him the charges that that would be submitted to the jury through translation, made sure he understood that. So wasn't there that discussion between a colloquy between the court and counsel?
I did not see that discussion. The next day, before the trial, before the jurors were brought in, the court did check in with Mr. Gurung and alerted him to what had happened the previous day. But at no point during that exchange was there confirmation or a check-in that he had knowingly and voluntarily waived his right to be present. And so that exchange did not solve or fix the problem.
Would
Moving-
his mere presence be enough?
I'm sorry?
Would his mere presence be enough? In other words, if he had been sitting in the back of the room during the charge conference or during the argument on the Rule 29, would that be enough, or would there need to be a demonstrated consultation with him, between him and counsel?
Right. I think that that's a closer question and would involve, whether he could hear, whether he was aware of what was going on. Again, though, we don't need to get into those nuances of the facts. So this presents a very clean and easy issue. He just was not there. There is no dispute that he wasn't brought to the courthouse that day. Moving on to so many issues that I don't want to run out of time.
Let me,
Yes.
before you choose your issue that you want to discuss, I think they're all important issues, but one that I wanted you to focus now on for me is the interpretation issue.
Thank you, Your Honor.
So as somebody where English is a learned language and interpretation is very important, and I've done my share of interpretation from Chinese to English and English to Chinese. You have filed 3 motions as to interpretation, the interpretation issue during the trial. So how do you specifically contend that the trial court erred? It's based on the three motions that have been filed.
Yes,
And also obviously how you briefed the issue.
the court's error here was failing to take reasonable measures to ensure that there was competent interpretation, such that Mr. Gurung had meaningful access to his own jury trial. And yes, I was about to move here because this issue too falls close to my own heart, as well as how egregious this rolled out during trial. It is clear, looking at the judiciary's language access manual, that a person with limited English proficiency, not no English spoken is not the standard, it's limited English proficiency, meaning some English words may be spoken. A person who is identifying himself as an LEP, limited English proficient, has a right to a competent interpreter provided by the court. The interpreter for the court is a court officer. The interpreter for the court swears an oath to abide by standards, including the court's language access manual. It is in the oath of the language itself. Here, as soon as defense counsel ascertained the extent of the problem, it alerted the court the next day. The issue first arose on the third day of jury trial, when the defense interpreter alerted defense counsel that there was a problem with some testimony and interpretation. And that was brought to the notice of the court, and the parties in the court dealt with it. And in fact, I understand the record is showing that it was struck. And so that was the first time that the court realized that there was some issue. It was the moment that caused defense counsel to go back to the defense attorney on that next day, which was a break. It was a break day, to find and catalog and fully understand the scope of the problem. Because as we know, running through trial, there are 1,000 things going and being thrown at defense counsel. Despite a request to have these interpretations recorded, they did not have that. And so the defense counsel was challenged.
And that is actually the direction of this court's language access manual.
Yes,
that
Your
says
Honor.
It should be recorded.
It couldn't be more clearly stated. It was also made known to the judge when defense counsel went into chambers that morning and expressed the concern shared, which was that the court interpreters, both of them, there were two that took turns, as required by the manual for some breaks, that both of them showed signs of incompetency. The signs were specific. The counsel told the court that the interpreter was not completing sentences, missing entire sentences, putting words together that are not exact sentences spoken, that in the gaps or silences in the courtroom where the English was spoken, there were sounds being made that no one else was making. There was an allegations that she was making her own sentences based on words she had heard from the court, that not many legal words were known, and that they couldn't find Nepali words for simple English. And they gave examples of the words where Nepali should have been spoken, but the court interpreters inserted English words. So these English words that were used, not Nepali words, were defense, testimonies, trauma, effect, accuracy. Now, if you're someone who doesn't understand what those words, the interpretation becomes unintelligible and rendered incomplete. In any event, the question and the concern here is, how did the court respond? And defense counsel asked, after alerting these specific problems, asked for two forms of relief. Please, Your Honor, record these so that going forward, we're only day 3 of trial and a 14-day trial that then turned into 4 days of jury deliberations and then on to sentencing. They specifically asked for an official court recording of these interpretations, which could have been a record button on the WebEx, because that was how it was being engaged.
So what's the result, Ms. Turner, of not having a record of the interpretation?
The result is what you have seen here, as we've tried, even here on appeal, to try to reconstruct a record through unofficial recordings, which was the best evidence that the defense counsel was forced to do, because the court refused to make an official recording. What defense counsel asked for in the alternative was, if you're not going to officially record, then may we record these? And so the court granted and allowed that.
So you do have that recording that is the recording of defense counsel.
Right.
And we're not talking obviously about the witnesses because that was verbatim translation. This is the colloquies between counsel, Mr. Gurung and the court.
No, the issue was involving all of the interpretation potentially. And the concerns then, so yes, the defense made these recordings, submitted it to the court in post-verdict motions to get it part of the court record. So it is part of the court record. And they had made selected drop downs to further analyze their recordings. And what they determined was that they found additional inaccuracies and also confirming inaccuracies previously relayed. And it was during voir dire. And the specific proffer made by defense counsel in her motion and post-verdict was that during voir dire, questions by defense counsel to the jurors were just nonsensical because they were English words used instead. And so those words were included with specificity. And critically, it was the summary interpretation that was also again repeated and alerted to the trial court. Now, back to this court's interpretation language access manual. It could not be more clear on this point as well. Summary interpretation should never be used. It is a per se disqualification for interpretation before this court. It should never be used. It is raised multiple times. Now, the trial court, when the trial court heard these concerns, the trial court was hostile and immediately dismissive. Characterized the errors proffered as de minimis. And how could they be de minimis when this court's manual determined that they are per se disqualification of an interpreter? And so the second remedy that defense counsel asked, besides the recording of the interpretation, was to replace the interpreters. And the court refused to do that, and instead engaged in a procedure the next day that it was questionable merit or accuracy, asking the interpreters to self-assess how well they had interpreted the proceedings so far, but the answers we got, so not just the process of confirming the errors was flawed inherently, but the answers that the court heard confirmed that they were not competent. The answers that were provided said, yes, we are striving for 90% accuracy. I do my best. That's not even saying that 90% was achieved. There was no denying that English words were in fact being used instead of Nepali. That was readily accepted. In questions posed by the court to the interpreters, there was a clear showing that the interpreters were not understanding what was being asked. The court told the interpreter, it seems that the defense interpreter thinks his English is better than yours. And the response from the interpreter was, thank you, Your Honor. Now, again, time and time again, this record was made as clear as could be, given the fact that there was no recording, that the court should have stopped, that there were fundamental problems. And so in this instance where we don't have a record, despite attempts, even on appeal, to remand this back down to review, that this is the quintessential case where we cannot know the prejudice and it's impossible to determine, and so it should be presumed. Certainly the constitutional rights at issue here go to Mr. Gurung's fundamental rights, right to be present, right to prepare his defense, to counsel, to confrontation, due process. All of it was denied. He was effectively made absent, though he was in the courtroom. Now, the court finally determined that any errors were Mr. Gurung's fault because he did not alert the court or actually say that he could not understand. Now, that is an inherently flawed reasoning, certainly nowhere to be found in the court's language access manual, which does have a section on how to address problems that arise in the middle of trial. It was absolutely contemplated that just because you do the voir dire before trial and the interpreters take the oath, errors could still occur. And the trial judge here started right out of the bank being absolutely frustrated that it was too late just because it occurred on day 3, day 4 of trial. But
I think the trial court actually was, I think the words used by the trial court was the language access manual of this court isn't persuasive. Did he just say he characterized it as merely persuasive? It was,
Yes, Your Honor, that was my understanding as well. Again, I was struck, though, that ultimately the interpreter's oath includes that they are taking the oath to abide by the judiciary's policies on these issues. I would like to reserve the remainder of my time for rebuttal. Thank you.
Thank you very much. We'll hear from counsel for the appellee. Please come on up. And before you start, if you would, introduce yourself and your client.
Thank you. Good morning, Your Honors. May it please the court. I'm Assistant Attorney General Sophie Stratton, and I represent the state of Vermont, the appellee in this matter. So at the outset, the Attorney General had the authority to refile the charges that were initially dismissed by the state's attorney in this matter. Nothing that the state's attorney stated in the dismissal of the first prosecution bound the state or barred the refiling of charges later. Second, the state asserts that the appellant received competent interpretation services during this trial that comported with due
so,
process.
Ms. Stratton, I understood from the trial record that when defense counsel asked if the interpretation could be recorded, you objected. Is that correct?
I don't believe so, Your Honor. I believe when defense counsel initially moved, because the court asked the parties to file preliminary briefing on how they would like to address interpretation at trial. In that, I believe that defense asked this interpretation be simultaneous.
Well, there were several requests by
There
the
were
defense.
several.
Okay, so let me finish. So there were several requests by the defense, and I believe it was after defense counsel alerted the court to Mr. Gurung not understanding the interpretation, or there was concerns, not understand, but there were some concerns about the accuracy of the translation. I think it may have been about the third or fourth time it was raised. And defense counsel asked, may we please record the interpretation? It really simply was pushing the WebEx button and to record, and it was consistent with this court's language access manual. My recollection of the transcript is at that point, the state objected.
That's correct, Your Honor.
So why would you object if this court has a language access manual that directs best practices and it is to record the interpretation?
In the pretrial motions, Your Honor, the state, I don't believe, objected to the recording of the simultaneous interpretation. To be part of the court's record, the court responded in an order that it was not required by due process, that the language access manual was a recommendation as opposed to a requirement, and also that the court did not have the logistical or technological capability to record the interpreted proceedings and make them part of the record, and that was the court's ruling. If defense had wanted consecutive interpretation, then everything that was
I understand
interpreted-
that.
And so.
No, let me finish. I'm sorry, okay? I understand that by the court's initial ruling. I'm asking why during trial you would object if that is what is recommended as best practices.
Because at that point, there had been multiple days of jury selection that had not been recorded. The state's entire case in chief had been presented and closed and had not been recorded. And so the state anticipated that any alleged errors that occurred in that time, I think part of the trial court's frustration is that he ordered that any issues with interpretation be raised as they were happening so that they could be addressed at the time, so that if there was an issue with interpretation of a witness's testimony or questioning or anything that had happened up to that point, that it could be addressed at that time while the record was still open. That had not happened, and I think part of the trial court's frustration is that late in the trial, I believe on the fourth day when the defense was presenting its case, defense notified the court of what it claimed was cumulative errors in interpretation that had been consistent throughout the course of the proceedings that they had decided did not raise to the level of bringing it to the court's attention until that point in the proceeding. And then the trial court was frustrated because it had told the parties explicitly to raise any issues with interpretation or they would be waived. At that point, the state objected because any recordings that were part of the proceeding would not have been complete and would not have captured all of the evidence that the state had presented in its
It would
case.
give some, Mr. Adnan, it would give some evidence to show whether or not there was a discrepancy for either the trial court to review later or for this court to review on the level of translation, whether or not it was even at 90%.
So the state's position is that the trial court was correct in directing the parties to raise any issues with interpretation during the trial while they could be addressed by the trial court. To allow a procedure where simultaneous interpretation of a trial, especially a lengthy, serious one like this, that happen and then that recording be reviewed post-trial for issues that were not raised during the trial with interpretation so that they could be addressed. The state's position is that that creates a very problematic situation in which there is post-trial or post-hoc review of interpretation of proceedings that may or may not have meaningfully impacted a defendant's ability to understand and participate in the trial.
For the jury trial, it's a very fluid transaction. I mean, a very fluid situation. Things happen all the time. Situations occur and change during a jury trial, especially a long one. And so when it was brought to the court's attention, wouldn't it have been best practices is to monitor it and manage it better?
The trial court, I think, addressed the issue as best it could, which was to hold a hearing mid-trial, swear the interpreters and question them under oath about the accuracy of their interpretation, whether they were achieving the recommended 90% accuracy with regards to simultaneous interpretation, to explain any of the errors that were alleged by defense counsel's interpreter, and also to have them testify to the accuracy of the other interpreter's interpretation. All of that was done under oath. They stated that they believed that they were testifying accurate or interpreting accurately. And I think that the trial court's determination that that was credible and that the issues raised by defense counsel of any accumulated errors in interpretation in the trial up to that point, the court did consider it de minimis and also had no evidence before it that it was affecting defendants' ability to understand or meaningfully participate in the trial, which is what due process required. The state's position is that the trial court is entitled to deference on the factual findings of weighing the credibility of the testimony of the interpreters. So at that point, the state's understanding was the court maintained that it did not have the technological capability, even though defense asserts that it's as simple as pressing record on WebEx. I think in the defense's post-trial motions, that led to the submission of 4 thumb drives containing lengthy video trials of recordings of simultaneous interpretation to be later parsed and translated and interpreted. The state took the court at its word that it did not have the technological or logistical ability to then begin recording simultaneous interpretations and make that part of the court record. I think the court also found that there was no legitimate basis that had been raised warranting that kind of intervention by the trial court or that kind of remediation.
Can I take you in a different direction?
Yes, thank you, Chief.
So it's interesting to me, we've had a number of cases. If you push the wrong button, you'll take off. Thank you. We've had a number of cases this spring and now early summer that have questions about video evidence in them. And I have a concern about the influence of video evidence that may be disproportionate to the testimony of witnesses, for instance. And in this case, we've got apparently video evidence that's quite gruesome, very, very graphic. And although I understand, I think there was no objection filed with regard to the specific issue that the appellant is raising. The evidence was requested by the jury, was in the jury room for a period of time. I'm not clear how long. And the appellant is arguing there should have been some limitation placed on the availability of the evidence to the jurors in the jury room. What do you say about that?
So Your Honor, the defense counsel moved to exclude that evidence entirely under Rule
What,
403.
right, but that, and
and
the
then-
court took that seriously. The trial court was very concerned about that evidence in that context, which is one of the reasons why I'm asking about it, sort of giving it to the jury wholesale and allowing them to have it over a long period of time.
Initially, the trial court ruled that the video could only be played once during the state's case in chief and not again, and would not be available to the jury during deliberations. And the state did not move the court to reconsider that ruling until during deliberations. Well, first, I think the state noted to the trial court that there was no legal authority that evidence admitted unless under special circumstances, say a murder weapon, something could be dangerous, contraband, but once admitted, that evidence should not go back to the jury to be considered during deliberations. But during deliberations, well, I think first it's important to note that during closing argument and throughout the trial, the experts referenced the video heavily. It wasn't just part of the state's case in chief proving that Mr. Gurung murdered Yogeswari Khadka. It was also important and the best evidence of defendant's mental state at the time, which one of the defense experts described as exhibiting florid psychosis, a frenzy. Defense counsel also emphasized the video very heavily in their closing argument, providing multiple timestamps, reenacting portions of it,
Well, no,
directing the jury
I
to-
understand all that. What I'm concerned about is the potential for influencing a serious bias on the part of the jury to have such elaborate access to it. That's what I'm worried about.
The jury requested the ability to play and pause, I think in part because a large part of the defense's affirmative defense of insanity was the argument that Mr. Gurung was in a trance until, as shown in the video, a citizen bystander who attempted to intervene brushed up against him, and that broke the period of what defense was asserting was this florid psychosis where he could not conform his conduct. So the state's belief is that that is in large part why the jury wanted to have access to play and pause the video. I think this evidence was graphic, but the charges were serious. For evidence to be excluded under 403 has to be unfairly prejudicial, but here the video depicted both the charged conduct and the defendant's mental state at the time of the offense.
Didn't defense counsel ultimately say that it would be good for the jury to have this tape?
Yes.
And having that in mind, to now say it was error for them to have it, isn't that invited error?
Yes, Your Honor. So defense counsel did acquiesce, and again, it was a big part of their affirmative defense. I think also, there was extensive evidence presented. There was other graphic evidence, including the body cameras of the officers who responded, but I think there was no indication to the trial court the jury could not appropriately weigh that evidence or would be so biased because it was never really a question that Mr. Gurung violently murdered Yogeswari Khadka.
Well, that's exactly the point. I don't think there was any question. And it seems to me that the trial court has a obligation, irrespective of what the attorneys may want to argue in one situation or another, to control the evidence and control the courtroom, and that's what I'm asking about. I understand lawyers are going to take different positions for strategic reasons during the trial, but at the same time, I would expect a trial court is going to control the evidence to make sure that there is an undue influence that is allowed. Do you agree with that principle?
To a degree, Your Honor, I think the state has the obligation, both sides, in fact, in this case, because the video was not just dispositive of the state's case in chief, but also was a large part and heavily relied upon in defense counsel's affirmative insanity defense. So the graphic nature of the video was not the only thing that it was being offered
Yeah,
to
okay.
show.
I
And
get
so I think juries are, entitled to credit to be able to weigh evidence appropriately. They were instructed that they should not, in their deliberations, be prejudiced by sympathies or bias towards either party. I think the jury was well aware, having seen the video, of the graphic nature, and then requested it in deliberation so that they could be deliberative around it, not just to review the shocking nature of the video. I think they were trying to handle that evidence conscientiously. And again, defense counsel, I think, agreed to it for strategic reasons. It was a large part of their affirmative defense. I think the trial court does have an obligation. The autopsy photos in this case were excluded. I think if there had been requests to view other portions of the body cameras of responding officers that were graphic, I think the court would have engaged. But the court did inquire of the jury. We think the best way to do this is to send the video back so that you have the ability to play and pause and rewind, because that was their specific request, and that would have been very difficult to do without potentially drawing out information about what the jury was looking for in their deliberations in the open court. So I think it was thoughtfully done, Your Honor. I
All right.
understand.
Thank you very much. I appreciate your response.
So, Your Honors, I'm happy to answer any questions. But at this point, I would like to move to whether the dismissal of the previous prosecution or anything stated in the notice of dismissal or the proceedings below was binding on the state or barred subsequent prosecution. So regarding the Attorney General's authority, it's clear by statute that the Attorney General has the same authority in criminal cases as the state's attorneys, is granted general supervisory powers and advisory powers with respect to state's attorneys, and specifically has statutory authority to enter into any homicide proceedings when, in the Attorney General's judgment, the interests of the state so require. This court held in Windsor that the Attorney General's office and the state's attorney share equal authority to initiate criminal proceedings, and as in that case, the state's attorney's dismissal without prejudice here did not move the state to any course of action.
Fran, was there a specific finding of insanity at the time of the act? Not competency, but insanity at the time? From the first, when Chittenden County State's Attorney brought the case?
From the state's perspective, no, Your Honor. I think that's a very complicated question, I think. So appellant posits two pieces of information or statements made, or sources of information by statements made by the state's attorney at the time of the dismissal. Regarding the transcripts that are the subject of the motion to take judicial notice, this court appellant moved to supplement the record with the documents from the first docket from the case file. And the state opposed, and this court denied that request. So the state submits that on that basis, the transcript should not be considered for the truth of what they assert. I think this court's holdings surrounding Rule 201, that judicial notice shall not be taken of transcripts or proceedings in another matter, in the matter before it, is also binding. But in the alternative, I think appellant asks this court to find that the notice of dismissal and the state's representations during the status conferences in the first prosecution constituted binding judicial admissions to sanity. So first, the state believes that these are not judicial admissions. There are 5 strict requirements for what constitutes a judicial admission, and one is that it is testimony to a fact which is within the witness's personal knowledge. It has to be clear and an unequivocal concession of fact, absolute and without qualification. Those criteria are not met by anything in the record before the court. Now, should this court consider the transcripts in the earlier proceeding, the trial court explicitly told the parties that any agreements or stipulations have to be approved by the court. And the trial court also noted, and the state agrees, that even if the state had wanted to stipulate the ultimate issue of sanity, it could not do so. There's no plea of not guilty by reason of insanity in Vermont under Criminal Rule 11A. In State v. Latham, this court has also indicated that it is clear that a plea of not guilty by reason of insanity is abolished, and it is not proper under the rules. I think the trial court noted in the state's position is that first, in order to stipulate to sanity, the state had to prove that Mr. Gurung was guilty beyond a reasonable doubt before the burden shifted. And in order to do that, there was required to be a presentation of evidence for the trier of fact to find that Mr. Gurung was guilty beyond a reasonable doubt. And then there needed to be a presentation on the issue of whether Mr. Gurung had met his burden by a preponderance of the evidence. This court clearly held in State v. Clark that sanity is an issue for the jury to decide at a trial on the merits. Now here, the notice of dismissal stated that the state could not prove beyond a reasonable doubt that Mr. Gurung committed the alleged offense, murdered Yogeswari Khadka, and attempted to murder Tulasa Ramal when she came to her daughter's aid. But the evidence in the state's case in chief on that point was overwhelming. It was then defendant's burden to prove to the trier of fact, either the judge or the jury, by a preponderance that he was insane at the time, and then the state can choose whether or not to rebut that evidence. But the state believes that the determination of sanity in Vermont at its heart is a community standard, that when a defendant asks for absolution for some of the most serious crimes because he was insane at the time of the offense, that evidence has to be presented, and that the victims in this case were entitled to access to the judicial system and to the process. I think the trial court noted that regardless of the outcome of the proceedings, there still needed to be a presentation of evidence for the trier of fact to determine sanity, and that was not something that the state could stipulate to. So regarding any argument that appellant makes that there was a judicial admission or stipulation to defendant's sanity at the time of the offense, I think that was explicitly rejected in the proceedings below, both in the first prosecution and later in defendant's motion to dismiss. And the state submits that there is not a legal avenue for the state's attorney to stipulate to sanity, nor should there be under the law and as it currently stands. Now, the Attorney General understands that state's attorneys' decisions whether or not to prosecute a case are entitled to great deference, and that this was a unique situation, and that determination was not made lightly to refile charges in this case. In the notice of dismissal, the state's attorney expressed an opinion, again, not a judicial admission binding on the state, that it could not rebut defendant's insanity based on the evidence available at that time. But the state submits that reasonable minds can differ on the weight of the evidence in a given case or what justice requires in taking a case forward or not. I think it's also important to consider what would have prevented the refiling of charges in this case, which would have been a dismissal with prejudice, or if the state had started a bench trial, jeopardy would have attached. If there were stipulations that were accepted into the record, factual admissions during the presentation of evidence at a bench trial in the first prosecution, then likely under that scenario, those would have been judicial admissions that the state would be bound by moving forward in any later prosecution. I'll also note that in the printed case, the trial court noted in a footnote in its order denying defendant's motion to dismiss in the second prosecution that the argument that the state's attorney made judicial admissions that were binding on the state going forward was not raised, and the trial court explicitly declined to address it. So for that reason, the state believes again that that if there were judicial admissions, that was not raised below for the trial court to address and make those factual findings as to whether there were in fact admissions or not. So I'll touch on defendant's argument that the court should have given a jury instruction on sanity. So this was raised below, but the law is clear, and this court has held that the jury does not have the right to consider the question of punishment in its deliberations, because knowledge concerning punishment cannot aid a jury in determining whether or not a defendant is guilty of the offense charged. More specifically, in State v. Smith, this court has held that the trial court, in fact, should not instruct a jury on the consequences of a not guilty by reason of insanity verdict. And even in State v. Percy, where the prosecutor made an ambiguous remark suggesting that a defendant may go free if the jury found that they were not guilty by reason of insanity, this court ruled that even in that situation, an instruction on the consequence of an NGRI verdict was not appropriate. I think important to consider in that analysis as well is that unlike many other states, in Vermont, there's no forensic psychiatric facility, and the procedures that follow a not guilty by reason of insanity verdict are very fact specific and would be very difficult to distill into an informative instruction that would actually help the jury in any determination that they are charged with making. I'm sure as this court's aware, after an NGRI verdict, the court must then determine whether a defendant is a person in need of treatment, must decide whether they're going to be ordered hospitalized or not. It's a very fact-specific determination. And so even if the court had decided that it was appropriate to give an instruction in that regard, what that instruction would have looked like and whether it would have given the jury an accurate understanding of the proceedings in the event of an NGRI verdict, I think is very difficult, if not impossible.
Ms. Stratton, I want to go back to a question that I asked Ms. Turner, and that is when structural error or is waived, and then in this case is the voir dire issue and the defendant not being present, when the court decided to do the voir dire, finish it in chambers. Do you agree with a plain error analysis, and does prejudice have to be shown?
The state does agree with the plain error analysis. I think importantly, when issues are waived, they can't be addressed by the trial court, and plain error is a high burden that the state does not believe is met here. I think the exercise of peremptory challenges, I know appellant noted that it was summarily announced. The state's recollection in reading the transcripts was that it was a question posed to defense counsel as to whether it was okay for peremptory challenges to be exercised in chambers. I think that's common practice for that to be done either at the bench or in chambers for a number of strategic reasons. And defense acquiesced to that. And in fact, it's even caught on the record that as we entered chambers, defense counsel said, "I'm going to close the door," essentially so that the jury could not overhear any of the discussion or exercises of peremptory challenges. I think what's also important to note is that there's no evidence in the record that prior to the exercise of peremptory challenges that Mr. Gurung was not consulted in making those decisions. It was simply the exercise and the procedure of how the exercises and the procedure and logistics of how that was done that was carried first. I think as well, this was an hour and a half out of 4 days of jury selection with extensive questioning, both individual and general voir dire. So with it being waived below, and the state submits it's not just waived, it was invited. Defense counsel explicitly agreed. And
I kind of thought maybe she just went along with it and so, I mean, forfeit it rather than waive, but you would argue that it was waived.
Yes, Your Honor. The state submits that it was waived, that the court asked a question of the attorneys whether it was okay for peremptory challenges to be exercised in chambers, and attorneys for both sides agreed.
Would there been a consultation, Ms. Stratton, on between the attorney and the defendant on as the jury gets reconstructed because of peremptory challenges for cause, challenges using the peremptory strikes?
I'm sorry, Your Honor, could you
Well,
repeat the question?
As people were exercising their peremptory challenges, either by challenges for cause, the jury's getting reconfigured as this process is going on. And so shouldn't there have been some consultation between the defendant and his counsel regarding how the jury was going to be reconvened as new people came into the panel?
And Your Honor, that may very well have happened. That wouldn't be part of the record. It certainly, I don't think, would be something that would be discussed on the record between defense counsel and the defendant, such that it would be subject to review. And I think if defense counsel had said that they wanted defendant present in chambers during the exercise of peremptory challenges, I think the court certainly would have accommodated that. But without that request or objecting to his presence during that exercise of peremptory challenges, there's no way for the trial court to address it. And I think it's elusive on review. And so I think also, as this court held in State v. Wynn, And as Rule 43 notes, presence during other proceedings is waivable. I think this court held in State v. Grace that the reason that the defendant's absence violated the right to confrontation was because there was a presentation of evidence that the defendant had personal knowledge of regarding the facts of the DUI stop. So the state submits that that's a different analysis than what's here. The argument on judgment for motion of acquittal and also the jury charge were questions of law. There were also, discussions I think that are reflected in the record daily as to transportation of Mr. Gurung, the timing of it, because during the trial he was hospitalized at Vermont Psychiatric Care Hospital. It was an hour drive each way. And there were discussions that Mr. Gurung at times was more comfortable staying at the hospital than he was being transported for trial, not during the presentation of evidence, but during legal arguments. And the record reflects that the court was consistent in checking in with defense counsel to see if presence was waived or not. I see I'm out of time.
Thank you very much.
Thank you all very much, Your Honors.
How much time does the appellant have, please?
Appellant has 5 minutes, 46 seconds remaining.
Counsel?
Your Honor, to quickly address your concern or question about the video and its submission to the jury during deliberations, it was submitted and they had 3 days of unlimited, unmonitored review. The error is certainly unpreserved, but it wasn't invited error. It was a question that the jurors asked. They asked to see the video, but it was the prosecutor who asked the court to allow the video to go back to the jury deliberations. And in that context, defense counsel said, fine. Now, that is not under any scope qualifying as invited error, a heightened, more specific requirements of deliberateness of defense counsel engagement. That's just not here. But moving on to responding to Apelli's argument, listening to her explanation, I did not hear her provide one as to why a recording of the interpretation of trial was not warranted going forward. Now, it cannot be that just because you missed the first 3 days and voir dire, that we don't need any. And so there was no valid reason or explanation that I could hear. And certainly the prosecutor vehemently objected to further recording. It provides us and puts us in a bind here on appeal, certainly put the defense attorneys in a bind going forward in the middle of trial, certainly turned this case into one where it is impossible for us to raise the comprehensiveness of the errors involved.
Wouldn't that be the value of recording? Even if it was late to ask for the recording, isn't the fact that there would be some basis tested against what actually was said if there had been a recording made even of a portion of it?
Yes, Your Honor. And of course, the value could have been that it showed even more new errors. But yes, so that was the value added. The other, turning to the presence issue, again, listening closely to how Apelli addressed these issues, it wasn't until Justice Waples, you affirmatively sought that request and response out, which I think is notable given that it is egregious and repeated structural plain error. There was no waiver of this right by defense counsel. The right to be present does not have to be affirmatively invoked by a criminal defendant for it to apply. It certainly doesn't have to be affirmatively invoked if you're a non-English speaker. Certainly doesn't have to be affirmatively invoked if you have mental health issues. The court was on notice that Mr. Gurung was limited English proficient. The court was on notice at this point, too, that there were interpretation issues. Certainly, they were having interpreters there, and mental health issues. And in this context, it was incumbent upon the court to make sure that these rights were, in fact, being knowingly and voluntarily waived. I think stepping back in the closing moments of this argument, I think it is critical to see the impact of the several errors that occurred during voir dire and trial deliberations and verdict, such that even if this court could find that no one although any one of these warrant reversal and sending this back for a new trial because Mr. Gurung's constitutional rights were just not protected when considered cumulatively. When considered cumulatively, they no doubt denied Mr. Gurung a fair and trial and his right to due process and to an impartial jury. And so on that ground alone, this is the case that this court could find cumulative error. Thank you.
Okay, thank you very much. Please call a conclusion of the hearing.